Well, welcome to ED&A. Whoa, that's got a good echo, isn't it? Different than our other room. So good morning. Welcome to ED&A. We have one bill today on the agenda, House Bill 655. I anticipate there's going to be a lot of testimony on this bill. So that's why we took the bigger room here and want to just say to everybody, we have a hard stop of 12 o'clock today that we have to be done. So I'm just going to ask everyone to try and keep your testimony to 3 minutes if you can, and try not to repeat other things you've heard. I know there's a lot of people that want to talk on and speak on this bill, so I'm just going to ask that you do that, and hopefully we can get through this and get all done by noon time. So with that, we'll open the hearing on House Bill 655, and I will recognize Representative Carol McGuire.
Good morning, Mr. Chair, Senators. I'm Carol McGuire, representing Merrimack District 27, which is the towns of Allenstown, Dunbarton, Epsom, and Hooksett. And I'm also the chair of House ED&A. This bill came out of a study committee that I and Senator Carson were on this past summer on the operation of the OPLC. And the study committee recommended that the functions and responsibilities of the board, of the OPLC office relative to the boards, be clarified and regularized. Because there was a lot of problem when interacting with various boards where neither the OPLC nor the board felt that the statutory authority was clear. So this is an attempt to do that. What it does, as amended by the House, it gives the organization of the OPLC and its duties and responsibilities. No board is specifically mentioned, except as being attached to the OPLC. We did not change the governing statute of any board in the bill as amended by the House. The original version did, but the House felt that was a little bit, we didn't have time to go through that in as much detail as we would like, so we eliminated about half the bill. We also expanded the areas that we had testimony were unclear or not properly expanded on, particularly investigations and discipline. The OPLC maintains the investigators, but not the boards. And the investigators are chosen to be appropriate in knowledge, particularly that they have to have specific knowledge of the profession they're investigating. Doesn't do you any good to have a plumbing inspector look at the electrician's work or other similar details. So the inspectors are and investigators are intended to have the level of skill appropriate for the job. They're also independent because this being a small state, we frequently have problems where everybody in the profession knows everybody else. And so if you have a serious case of misconduct, you want to bring in an outside investigator because otherwise, like I said, everybody knows everybody else. And so that's the essence of the bill. It consolidates all of the administrative functions from issuing licenses that don't need board approval to reissuing, keeping track of continuing education, maintaining minutes and posting the board meetings and things like that. So what this should do is lessen the work for the boards in that they will only need to approve licenses if they have some non-quantifiable requirements, which some boards do, or if the person applying has an issue, whether it's a criminal background check that's not perfectly clean, or they're not quite in alignment with some of the requirements. the board will review that. If they have a clean background check, then the licensing clerk can issue the license. That will make things run a lot more smoothly and also faster. There's a lot of people who want to tell you where we didn't make the correct changes or should have done something different. So I will just answer your questions at this point.
Thank you. Any questions? Senator Altshuler.
Thank you, Mr. Chair. And thank you for taking my question. My concern is on page 12.
I'm sorry, I've only got
Nope, sorry.
I've only got the PDF, so if you could tell me what section it is?
It is section 310.12.
Okay.
Oh, no, 310.13.
31013.
310.13, unlicensed practice.
Okay, that's 1113.
Yeah.
Unlicensed practice. Yes,
Unlicensed
that is,
practice. So my question is, who, in this language, who not being licensed or otherwise authorized to practice according to the laws of the state advertises oneself as engaging in a profession licensed or certified, or in any way holds oneself out qualified to do so.
yes, this is a consolidation of the unlicensed practice section, which is in almost every professional licensing. Some professions have different requirements. For example, accountants don't need to be licensed unless they're a CPA.
I'm sorry, what?
Accountants don't need to be licensed unless they're a CPA. There are some things that only a CPA can do, but an accountant is perfectly legitimate to practice and to advertise him or herself as an accountant. The same way with engineers.
May I follow up?
Sure.
Regarding regarding the statement you made earlier about the board not being, I think I'm troubled by the statement you made earlier about not allowing, and if I understood you correctly, OPLC to do what they're charged with now and having to hire independent evaluators.
Not evaluators, investigators.
Investigators.
The board remain as the jury of, I don't know what they're called. They evaluate the facts of the case and decide if what has happened is a violation of professional practice or the law.
And at whose cost?
The OPLC is funded from licensing revenues.
Sure.
At the moment, it generates a surplus and which rolls over into the general fund. But there is enough money flowing to and through the OPLC to investigate any cases that are necessary. Licensing boards were traditionally asked to provide 125% of their costs, where the 25% was intended to cover overhead that may not be there every year, or major investigations, or hiring a lawyer or an outside investigator or whatever. But when all the boards got piled together, it turned out they had a bit more of a contingency than they had anticipated, and so they are consistently rolling funds to the general fund. There are at least 2 bills addressing that, one from the House and one from the Senate. So we will, it's only mildly mentioned in 655 about the funding.
Okay. For the moment, thank you. Good.
Further questions? Seeing none? Thank you.
All right, thank you. If you don't mind, I will leave you to the tender mercies of the rest of my committee and the people who are here, because we've got hearings in the House today.
Well, we appreciate you coming in. Representative Hope Damon. You've signed up to speak and you oppose. Welcome.
Good morning, Mr. Chair and committee, and thank you for taking me before my other hearings. And yes, I signed up in opposition, but to be more clear, I have concerns, some of which may have just been addressed by Representative McGuire. So I'll just address my prepared remarks about what the concerns are with the intent that the committee will take account of that, please. I am Representative Hope Damon, Sullivan District 8. I represent the 9 towns of Ackworth, Langdon, Leominster, Goshen, Washington, Springfield, Sunapee, my hometown of Croydon, and the rising city of Claremont. Do come visit. I serve on the very busy House Education Committee. I am a licensed dietitian under the New Hampshire Board of Licensed Dietitians. I recently retired from a 43-year career that included hospital, nursing home, substance treatment, and private practice, with an emphasis on diabetes care and eating disorders treatment. I loved being a dietitian. I also loved being a rep. I'm a member of the New Hampshire Academy of Nutrition and Dietetics and affiliate of the National Academy of Nutrition and Dietetics. And I was president of New Hampshire Dietetic Association, which is the predecessor to the New Hampshire Academy of Nutrition and Dietetics, when licensure of dietitians was being established in New Hampshire. I think we started talking about it in the mid-'80s. I have significant concerns about House Bill 655 and House Bill 2, Section 108, although I will acknowledge that there is potential merit to consolidating administration of healthcare professional licensure under one agency. Both bills provide the same concerning language addressing changes to professional licensing boards. Passage of either of these bills could disrupt the basic protective functions of our board, which I value and believe are necessary to protect the public safety and well-being. Just a bit of background, dietitians provide medical nutrition therapy to whoever needs it, your family, your friends, neighbors, perhaps yourselves. We are extensively educated and experienced healthcare professionals with unique abilities. We not only educate about nutrition related to various diseases and conditions, but we are skilled in motivational interviewing and behavior change. That combination of nutrition knowledge with the skills to support patients applying what they have learned is the essence of our work. It is much more than just suggesting how to eat. It is helping patients make practical, sustainable, enjoyable choices that become their food routines. The services of a licensed dietitian or any professional are of no merit as the public is unable to obtain them. Licensure helps the public determine who is a qualified provider of scientifically accurate nutrition care. It's not unusual for people to be unaware of the differences between dietitians and nutritionists. So to be succinct, dietitians have a 4 to 5 year degree, national registration exam, and continuing ed credits. I won't go into the weeds. Nutritionists are anyone who wants to call themselves a nutritionist. Your plumber, who may be a superb plumber but probably doesn't have expertise in nutrition, could in fact decide to hang out a shingle. So there's quite a difference in that terminology. I'm just going to skip a part here because I know you guys have a lot to hear. It's not clear to me in the language of House Bill 655 whether existing licensure boards will function under the umbrella of the expanded OPLC with the same membership of the boards and same responsibilities, or is the intent to create a single generalized board of licensure such that people with little or no knowledge of dietitian practice would compose the licensing board? I think clarity on this is essential. Representative McGuire did reference that the existing boards would transfer to the umbrella organization. It's not as clear to me in the language of the bill that the membership of those boards would be retained with the expertise that they should have. The other aspect of access to care is affordability. Passage of these bills puts access to covered healthcare services at risk if we don't protect licensure of healthcare professionals, because health insurers generally provide more robust care in states where practitioners are licensed. I know as a dietitian, I could not get reimbursement for services from Medicare, Anthem, Harvard Pilgrim, the rest of the insurers, if I were not licensed even with all the same credentials as a nationally registered RD, they want licensure. And if it's not covered by the primary payers for healthcare, then it's not accessible to our constituents. People will pay out of pocket to the degree that they can, but for many people, that's zero. My last note, medical nutrition therapy is a very cost-effective care. For example, when people with diabetes receive thorough contemporary nutrition care, they have far fewer complications that are expensive to treat. We're not very expensive, we dietitians, not for the value, and I realize I have a biased interest here. But truly, what we cost compared to what we save, it's well documented that it's very cost effective. I thank you all for your time and your very hard work.
Any questions? Seeing none, thank you. We appreciate you coming in.
Thank you.
Jackie Grody, EDNA Committee. Good morning.
Good morning. Thank you. My name is Jackie Groda. I'm the state representative representing Rockingham 24, the towns of Greenland and Rye. I sit on the EDNA committee, and I chair the subcommittee for House Bill 655. So 655 originally was a monstrous bill, and we had a lot of testimony from boards that were concerned about the disciplinary actions that would result, the responsibility for disciplinary actions that would result from House Bill 655. It was also put in House Bill 2. So there were two places to find the exact document. So what we chose to do as a committee, and it was a unanimous amendment, we took the parts of House Bill 655 that had to do with the OPL structure, and we passed that. And the rest of it, we left as we left it in our committee. And we also presented the case to Division 1, and they withdrew House Bill 465 from House Bill 2, and they left some portions of it, which I can send to you. So some of it is still, for example, it repeals the hawkers and peddlers. It repeals itinerant vendors. It does some changes that are just neaten things up, right? So this is an amendment a proposed amendment to the House Bill 2 that EDNA would agree to unanimously. I've been assigned the responsibility of being the subcommittee chair for House Bill 465 and House Bill 2, the leftovers, let's say. And our plan is to review those things and to make sure that the issue at hand is that investigation and adjudication is separate, that we don't combine those, and that we address disciplinary actions in a way that is conducive to public safety and to the proper means of doing these things. So I just wanted to bring you up to date as to where we are. And I think that there's no doubt in our minds that there are changes that could be made, but we want them to be made in conjunction with board support so that those individuals who are responsible for their boards have a say. Lastly, you should know that one of the issues that boards have had is the lack of a quorum. And we recently passed a bill in the House that is on its way to you, that I hope you'll all vote for, that allows virtual participation with respect to state boards, so that it helps some of these boards attain quorums.
Thank you.
You're welcome.
Any questions? Senator Perkins Quokka.
Thank you, Representative, for being here, and I hope to keep in close touch with you as we hear the testimony. So, in reviewing the version amended by the House, there's obviously some elements here that relate to disciplinary proceedings. Are we to assume that what came through in the amended version of the bill reflects areas where there was consensus at your
Yes.
committee?
Yes, and it also includes comments that were made by the boards and concerned professionals involving rec and retention and telemedicine. Those are two chapters that were included in House Bill 465.
Yeah. Okay, just to follow up, if I may, Chair. And so if I heard you correctly, have all parts of HB 655 been removed from HB 2 pursuant to your amendment?
Except for a few things, and I do have a list here, and I can send this to you if you'd like.
Please do.
Okay.
I will.
Okay, thank you. And just one more, if I may,
more
Chair.
follow-up,
You and I worked together last fall on the licensure of mental health professionals, and one of the big issues that came up in there was sort of endorsement or interstate compacts. I see that sort of lightly reflected in this version, but is that an issue that you felt like was particularly relevant to this bill, or that was left in committee?
That part was left in committee,
Okay.
but it's part of the expansion of availability of services. So it's something that, and each board has already compacts.
Yep.
I mean, they're like the Board of Nursing has a compact.
Correct.
So we just want to make sure that we didn't conflict
Yep.
with existing
Yep.
agreements. That's why we'll really have to look at this on a almost board by board basis.
Sure. Okay. Thank you, Chair.
Any further questions? Seeing none, thank you.
Thank you.
Next, we'll bring up, I'm sorry. Yeah, go ahead.
Mr. Chair, I'd like to mention that although there are still some pieces in House Bill 2 that address licensing, there is no section that is included in House Bill 655 and in House Bill 2. They don't amend the same statutes, although we do have a very thick book of licensing statutes. They have different sections of it. I just want to reassure you, there's no need to carry two bills through the process that are amending the same section.
Thank you for the clarification. Lindsay Courtney from OPLC. If you've got anybody else you want to bring up with you, Lindsay, you're welcome to from your department. Good morning.
Good morning, Mr. Chair, members of the committee. For the record, I'm Lindsay Courtney. I'm the Executive Director of the Office of Professional Licensure and Certification.
Douglas Osterhout, General Counsel for the OPLC.
So thank you for the opportunity to address you and appear before you in support of House Bill 655. As Representative McGuire mentioned, this really is the result of a study committee recommendations that was a bipartisan effort last session, and they made several recommendations, one of which was to clarify the roles and responsibilities between the office and the boards. I think there's a lot of misunderstandings as to what this bill is really intended to do, so I just wanted to touch upon what we think the bill actually does. First, with respect to licensing, it makes clear that OPLC can license individuals in between board meetings without having to have an MOU with the board. As it presently stands, most of the boards have already delegated that responsibility to OPLC because the licensing criteria is objective for most boards. So nursing, for example, we receive thousands of applications. We don't bring those to the boards to review unless there's a problem. This would just make it clear that we have that statutory authority to do so. The LBA in several audits has mentioned that it does not believe that the boards can delegate that authority, and so this is intended to allow them to do so and allow us to issue licenses in between meetings. With respect to investigations, what it does is it creates one mechanism for how the office is supposed to handle investigations. Right now, most boards if not all of them, have very similar language regarding investigations, but the authority derives from the board's authority to conduct an investigation. So we have to request permission from the boards to initiate an investigation. This would allow us to investigate an investigation by allowing us to investigate prior to receiving board approval. What is clear in this bill is that all decisions, whether it be to dismiss an investigation or complaint or to adjudicate a claim, would be made by the board. Any final disposition would be made by the board. I think there's been some confusion about that, so I just wanted to make that clear. And then it also clarifies that the boards are the finders of fact in adjudications, and that a qualified OPLC hearings officer can make finding or rulings of law on evidentiary motions or other legal questions, which we presently already assist the boards with, but it just kind of codifies that existing structure. I also want to mention that there is no proposed change to the actual boards. There's no intent to get rid of the boards. There's no intent to change the composition of the boards. In fact, I think it's section 310.2, as proposed, all of the boards are incorporated within OPLC, and their statutory references are right there, and those statutes establish those boards, and there's no proposed changes. With respect to endorsement, this really is a workforce bill. Licensure is absolutely necessary to protect the public, as the general court has found. But what we observed, particularly through COVID, was that having to bring applications to board meetings on a monthly or every other month basis slowed down the process for licensing individuals who are otherwise qualified. And so this is intended to allow us to speed up the process and be a little bit more competitive with other states who are doing it faster. Doug, would you like to add anything? Okay, with that, I'd be happy to answer any questions.
Thank you. Any questions? Senator Perkins Cook.
Or Perkins Coga. I noticed that your hearing officers were capable of making rulings of law. Are they normally licensed attorneys, your hearing officers, or?
Yes, it's part of their supplemental job description.
Okay, thank you. That was my only question.
Further questions?
Thank you for your time.
Seeing none, I'm sure we'll at some point be reaching out with some. Thank you. Okay. I guess we'll start at the top of the list now. Betsy Patton from the Assessing Standards. Good morning. Turn on your mic, please. Hit the button.
You do
There you
that?
go.
Okay, good morning, thank you. For the record, my name is Betsy Patton, and I am the chairman of the Assessing Standards Board. And our powers and duties in 21J 14B require that we recommend standards for the administration of the property tax and the assessment of real property. And DRA has the ability to, and the authority to, what do they say, enforce those standards. One of the things that is kind of confusing to me is that when I'm not sure, no, let me back up. On page 3, line 18, the Assessing Standards Board has been moved over to be under the OPLC. I don't know if you can find that, it's BBB. And we have recently wanted to have an assessing certification board, which would take and certify the assessors in the state. And it was never our intentions to take the whole ASB and put it over to OPLC, which apparently 655 does. So I would just like you to look at that and maybe perhaps find out whether that Assessing Standards Board should be the Assessing Certification Board. It's a brand-new board. There were some questions of the assessors of perhaps conflicts with DRA and how they certify the assessors, because they're also the ones that take away the certification that DRA does now. So I just would ask you to look at that. I know that I have tried to get some time with Lindsay, but because of this bill is so huge, I know that it is almost impossible. We are having a meeting Friday of the Assessing Standards Board, so maybe I can at least tell them I was here and talk to you about, hopefully, that this is something that should just be the Assessing Certification Board, not the Standards Board. Thank you.
Thank you. Any questions? Seeing none?
Okay, thank
We
you.
appreciate it. Celia Oliver from the New Hampshire Psychological Association. Good morning.
Good morning.
Don't leave the red light on. Hit the button again, leave the red light on. No, hit it once more. There you go.
Oh, it is the red
There you
light.
go.
Okay. Thank you. It seems like that's stopped. I'm Dr. Celia Oliver, and thank you very much for hearing my testimony today. I am a psychologist, and I have been on the board of directors for the New Hampshire Psychological Association for at least 15 years. And I've also been chair of the ethics committee for NHPA for also about 15 years. And I attend most of the public portions of the Board of Psychology meetings so that we can help coordinate and get information out to other psychologists, et cetera. So overall, NHPA is happy about promoting anything that improves efficiency. So we're not absolutely against what's going on with 655. What we are very concerned about are how some of these things are going to be implemented. So, for example, especially around misconduct issues or allegations of such, the very specific words of allegation and complaint and investigations have very distinct meanings in our profession. So part of what happens for us is we are constantly being asked about our credentials with insurance contracts and also general credentialing boards through hospitals, et cetera, depending upon where we work. We have to go through those for each entity. Each entity usually asks us to reattest every 3 months. So it means basically at least once a month, you're doing some reattestation. Included in those questions are, have you ever been investigated or founded? But also, are you under current investigation? Right now, if it is simply an allegation, then we can say, no, we're not under investigation. If we have to check yes, it is highly likely that either our privileges and credentialing will be suspended or revoked. If that happens, then that means we cannot provide services in whatever entity that is, so for example, client with insurance coverage, if our privileges and provider status are revoked or suspended, then we cannot treat clients who have that insurance. So we're already strapped, as you know, in this state for appropriate services for all of the clients, and this would make it harder. So we're asking that it be clearly, these distinctions and definitions be clearly defined in the statute so that there is no difficulty around that. Similarly, although somewhat different, is around the idea of investigations. Psychology is an incredibly complicated field with many subspecialties. I've told you, I've been in this profession for 30 years as a clinical psychologist and 20 years prior to that in research. And I have a lot of experience with teaching and providing practice. And yet there are subspecialties within my field that I absolutely would not be qualified to investigate. So what currently happens with the Board of Psychology is if there is an allegation that is going forward to be investigated, then the board aligns the investigators to be experts within that subspecialty so that they are truly qualified to make appropriate investigations. So we are again asking that the criteria for investigators and how they are paired with professional being under investigation be very clearly defined. And finally, in this bill, there's words about, and I forgot to write up the exact words, but that if an investigation is founded, if misconduct is founded, that then the person being investigated can be charged for the costs. And currently in the statute, it says that there is a cap of $10,000. So we would like that cap to remain.
Thank you. Any
And I
questions?
think that's it for our list. So if
All
there's
right.
questions,
Any questions from the committee? Seeing none, we appreciate it.
thank you so much.
Next, we'll have Bob Quinn from the New Hampshire Realtors.
Good morning. My name is Bob Quinn. I am the CEO of the New Hampshire Association of Realtors. I didn't sign in either favor or opposition of the bill. We are neutral. But as Representative McGuire indicated, the purpose of the bill is to separate or identify the functions of the various boards and those of the OPLC. And the bill mainly deals with issues regarding administration, licensing, investigatory processes. One area where we're having some issues has been the approval of continuing education courses, where there has been some confusion regarding who is responsible, either the OPLC or the Real Estate Commission, in approving those. I've had some conversations with Executive Director Courtney on that issue. I've submitted a potential amendment that if you decide to move forward with this bill, we would ask to be included, as it doesn't mandate the requirement on either the OPLC nor the Real Estate Commission, but it does grant them both greater latitude in working together to ensure. Right now, we have about a 5-month backlog in approval of continuing education courses, and real estate licensees are required to take 15 hours before renewal. So it is creating some problems and some issues. So we do hope that you'll consider this amendment if you'd move forward with it.
Thank you. Any questions? Senator Perkins, welcome.
I'm the questioner today, I guess.
That's all right.
Okay, thank you, Mr. Quinn, for being here. So what you're proposing is we would essentially add this section of 331 on to the end of the bill that primarily deals with 310. And the purpose would be, is it that you guys are having trouble getting approval for courses that would qualify towards your practitioner's hours, or that once the hours are completed, you're not sort of receiving validation of those?
It would, thank you for the question, it would rectify the approval of new continuing education courses.
Okay.
So, right, the process used to be that it was a staff function.
Yeah.
Generally, it was either under the Real Estate Commission, then it became under the OPLC. There was a reinterpretation last fall in terms of what the statute indicated, and so now it is entirely a function of the Real Estate Commission. There was kind of a standoff between the commission and the OPLC
Okay.
in terms of the responsibility.
Okay.
So we're just trying to give them some more flexibility in determining and allowing for staff assistance. Real estate commissioners, they turn over all the time. They
Yeah.
may not have the background or the knowledge in terms of what's required under statute, where staff can be a big help in that process.
Okay. Just to clarify. Thank you, Chair.
Further questions? Seeing none, thank you for your testimony.
Thank you very much.
Next, we'll bring up Steve Rancourt. Good morning.
Good morning, Mr. Chairman and the committee members. Thank you for your time. I just have a small handout just to help touch base on a few of the points that we are concerned about and give you a visual with a little bit of backup as well, so it's not as bad as it looks. Our concern is a license, I'm licensed under the OPLC as well, and we are as a licensed electrician. There's some generic concerns that we have to the bill itself. And if you'll, based on that, the executive director itself is appointed by the governor's council, the governor's council. The director will nominate and be appointed by the governor's council, the director of Division of Licensing and Board Administration, the director of Division of Enforcement, the chief pharmacy compliance investigator, 2 pharmacy compliance investigators, agency chief legal officer, and board chief legal officer. These positions, as well as the executive director's positions, are appointed positions. We've been through quite a bit over the years as the electricians board. We were in the Department of Safety, had some issues, went into joint boards, now it's OPLC. To make sure that as the administrations change and as these positions change, we would ask that the boards have more input on it, because especially with the fees. And if you'll notice on the first page, I talk about section 310.6.1. And we'd like to add the wording that's in bold there if we could to that, because we feel that the way the wording is now talks about in consultation and advice and consultation. But the boards don't really have a say if the OPLC decides to, and it would prevent the board, the agency from becoming very politicized and changing. These agencies are 125 agencies. And to be blunt, they're cash cows, right? You just increase it, you get 25% more. Some goes to the general fund and some might stay in the non-lapsing fund now. We've been through that a few times and it's got abused. So it has nothing to do with the existing administration and executive. This is just in general going forward, because something like this could have a huge impact down the road. So we ask that you would add on section 310.6 Roman numeral 1, where it talks about fees, set forth the fees in 310.5, which I struggled to find. I'm not sure if that's 310A, but with the advice and recommendation of the respective boards. And the wording we want to add is notwithstanding, referencing the proper RSA, shall require an affirmative vote of 51% of all the boards within the OPLC. The OPLC and the joint board prior was supposed to be to help administratively and make us more efficient, but it's slowly been taking over control of things. So we just want to make sure there's a balance there. If they're setting fees and you can't get 51% of your boards out of 54 boards and 157,000 licenses to agree that they should have some input. So we thought that would be helpful to be added. You'll see in the back, it shows you their budget. It's going to be between 14 and 17 million with the 57 boards and all those licenses. The next section I talked about is in section 310.9V, which is actually page 8, line 29. The version's a little different that just came out, so the page numbers might be messed up. And this talks about them conducting inspections in places of business professionally regulated under the office. We feel that bold wording of non-residentially zoned should be added. I'm a small business. My office is in my house. I don't see why we should give the OPLC or the investigators the authority to walk into my house because I run my business from there. I just think that's a slippery slope, and we should just try to be careful for that. If you want to the next page, it talked about section 310.08, Roman numeral 2. It's actually on page 7, line 24. They talk about 2-year renewal and licensing, and there's been some confusion on it. We hope the board or the committee might be able to make sure it's clear before this goes forward. We happen to have been a 3-year renewal. It's gone to a 2-year renewal. We were told that the renewal would the fee would remain the same per year. So we're not going to keep our fee the same for 3 years and only get 2 years out of it. And I gave you an example. I showed you the journeyman and master licenses and stuff and their cost. When we call the office, we're getting mixed. We're being told that it's still going to be the same fee, but it's only a 2-year license. So if the committee could just make sure that that's clear in there, that our price per year would be the same. I understand it may go up in time, but just that we're not paying for 3 years for a 2-year license. Also, it mentions about apprentices, and they're certified / registered. They're not licensed, and they're done yearly. And we would hope that will remain that way because they have to show proof of schooling to renew their certification. If you give them a 2-year certification or registration, you're going to have people that might not go back to school. It might not fill out the proper information. So they're not licensed. We hope that that would stay 1 year as well. The 2-year renewal, like I said, it's done for the budget based on the biennium, but we hope that it will, we can clarify how that's being used and worked. The next section was 31014, Roman numeral 3. It's on page 17, actually, line 1. This is something we wanted to add under the appeals. Under section Roman numeral 3, it says, appeals from a decision on a rehearing shall be appealed by the Supreme Court pursuant to RSA 541. No sanction shall be stayed by the board. The bold that we're asking to add is except as allowed under RSA 674-34. That is attached in the back of your packet if you want to look. That gives us something as far as the professional boards. We have professional and occupational under OPLC, and there is a big difference in how things are handled, even though they're trying to standardize it. 674 allows us to appeal to the State Building Code Review Board based on interpretation and application of the code. So if there's a discrepancy between the installer and what the board might think the code's implied, it puts it in that first before having to go to Supreme Court. So we just ask that you consider adding that in. This has made a huge difference and been used many times, and it's very important if we get that to stay in there. And again, it's attached in the rear. Reciprocity between House Bill 2 and this, and there's been a lot of bouncing back and forth as far as what's in, what's out, what's changing. Since it's a recent update, hopefully if there's anything there, we reciprocate with 23 states almost through a program. We hope that will remain with substantial equivalent. We're all for reciprocal, again, 23 states, but the wording's been changed a couple of times, and we hope that we could make sure it's still with substantial equivalent for schooling and hours, and that not just, hey, you have a license in this state, and you come over here, and they have half the schooling or half the hours but you have a license. So we'd hope the committee would consider that. And then we had a concern about corporate licenses, which is again bouncing between House Bill 2 and this. They're trying to remove corporate license. I'm not sure they realize what it's really going to do. They felt that it said may issue a corporate license, and that made it voluntary, and they didn't need it, so they repealed it, or they want to repeal it, I think, in House Bill 2. That is, you will stop many businesses from operating in the state of New Hampshire if you do that, because they're required to get a corporate license, but it just says the board may issue it based on certain conditions. There's people that abuse it and they have to have a license of record. So we would hope that would stay in there. Plus you'll have a loss of revenue to the state for all those corporate licenses at $125 a year by the biennium. So that's all I have for now. I'm glad to answer any questions.
Thank you. Any questions? Senator Perkins Cook. I'll just start with you, Reach.
Thank you, Chair. Thank you for providing. Thank you, everyone. Thank you for providing the specific references for your comments. So just a couple of questions so I can make sure I understand. So your comment on what is now page 7, I think line
24.
Yeah, 24 through 26. So I hear your points. Since apprentices are not licensed, I don't really see this section as applying to them, but maybe you can educate me further on where apprentices are usually dealt with and how we can make sure that's covered.
They renew through the OPLC as well, through the electricians board or even the mechanical board.
Yeah.
And we're getting feedback from our members that they're telling them that that's going to go to 2-year licensing as well. So I just wanted to mention it because I haven't been able to find exactly where.
Okay.
But to make sure that if it goes forward, it's clear that it doesn't apply to apprentices. They should still be 1-year renewals
Okay.
as well as.
Okay. Thank you. So we're
Yep.
follow up if I may, Mr. Chair. We're both trying to locate that and make sure that it's covered. Yeah.
Depending on how they refer to it.
Yes. Okay.
In other areas, they refer to it as certification, registration, or a license. So that's why I'm just offering we need to vet it and make sure that it's not combined with the.
Got it.
Kind
Okay.
of make sure I'm clear. So
Yeah.
apprentices actually have a license? They just have a
They're
certification?
registered as an apprentice.
Registered, okay.
Registered.
Sometimes they use certified, depending on the profession, but ours are registered. Then they have to go through 4 years of OJT, and then in that, they do through 4 years of schooling. But each year, in order to renew your registration for apprentice,
Yep.
you have to show proof of that schooling. If they wait 2 years, now that gets lost in the void, and you're gonna have people not complying.
Okay, maybe that's a question we can follow up with OPLC. Okay, and then one more question if I
Follow up?
may, sir. I take your point on the rehearings that I think are now on page 17, but if I read this correctly, I mean, the appeals to the Supreme Court are for licensure decisions, and the appeals to the building code are for,
Application and interpretation of the code.
yeah, sort of a building inspector or, fire official. So it seems to me that the distinction would be clear based on who the adjudicating officer is, so if it's a building inspector acting, it would seem to be clear to be under 674 and vice versa. If it's an OPLC or board member acting, it would seem to fall under 310, but, I welcome feedback on my
Yeah, thank you for
sort
the
of
question.
question.
No, appreciate it. It does need some clarification. So we may go in front of the board because we violated a code application or installation.
I see.
So we're brought to the board, and we may receive disciplinary action from the board because of that. So it does go to the board and get processed through there. It's not just for licensor, like I was out of ratio or something like that. It's anything to do with our license. And code violations are part of it. Sometimes you will go into a project, the inspectors, and where they're doing retrofitting for tons of lighting, and they're not using the proper equipment, they're not using the proper wiring, they don't have licenses. So it's all tied together. That's why.
Understood. And then just one last one, if I may, Chair.
Sure.
Thank you. I'm having trouble locating the changes to RSA 319 in the version as amended.
As far as the corporate license,
Yes.
I don't believe, again, and it's amended, I haven't had a chance to read through it.
Okay.
And that was also into House Bill 2. So again, as these things, we've been trying to follow them, but I'm sure, as you know,
Yeah.
House Bill 2 was 200 pages. This bill originally was like 70 pages. We're blue collar workers every day trying to keep up with it, so.
I get it. Okay. All right. Thank you very much, Chair. Thank you.
Thank you.
I did have one more comment, if I could, Mr. Chair. On the 2-year license renewal, on page 2, it talks about valid from the date of issue. Right now, it's always been from when my license expires. Typically, it might be a birthday month, but if you have it state that now, you're going to create a loophole and a loss of income. Because let's say I can go 1 year before I renew my license without having to do an examination or something. So I'm not doing much, I'm just an employee, not necessarily a contractor. I let it go for 7-8 months, then I renew. They just changed my renewal date to that, so you lost all that income. I could do that for the next 10 years and gain 5 years of not paying for the license. I really think that should still be renewal upon whenever it is, whatever they choose, not just every time you renew it, because it changes the date that you renew consistently if somebody doesn't follow it. Plus, they're not paying for it. They'll do that. Some people will do that just so they don't have to, so. Thank you.
Thank you.
Thank you.
Further questions? Senator excuse me, Senator Altshuler, I'll get it.
Thank you. Thank you, Mr. Chair, and thank you for taking my questions. I was following along, and you moved at a brisk pace, though. I appreciate that.
I stay within my 3 minutes.
Yeah.
Yeah, we were closer to 10, but I let you keep going.
I know.
In your supporting documents on page 3, of your, this is yours, right? Yeah.
Sure.
Yeah, page 3, reciprocity. I also have deep concerns about reciprocity being appropriate, and agree with you that professional licenses should be substantially equivalent requirements. Where is that? Because I did a quick word search of the amended version. You haven't really looked at that yet, right? Or am I
Right.
missing it?
And I just picked it up this morning as well, so I don't know
worries.
if that's directly in there or not, if it's been removed again between House Bill 2, but
Okay.
you can also find more on RSA 332 G14. It's a little bit clearer in there, what we're supposedly doing right now. And a lot of these a lot of those changes that are happening, some are good, some are bad. We got to move through it. But if you look at like the fourth or fifth page, it gives you a little bit of information about OPLC number of licenses. If you look at the graph in it, you can see that some of this change has been forced by the three boards having the majority of the issues, so to speak. So
I know reciprocity is in a different House bill. It's not in this one. So
So it's not.
I think it's not in
I
655.
know we've heard it in a separate bill, but
Yeah.
it's not in this amended version because I
It is
couldn't
not.
find it. Okay.
And I think
Just checking.
Representative.
Yeah.
Drew-
And because they've been going back and
Okay.
forth with House Bill 2, I just wanted to mention it because I wasn't sure if it's being moved or not. Things keep moving fluidly with those two bills, right, these two bills, so,
All right, we thank you.
thank you.
So,
right,
so
next.
I'm clear that that was what Representative Gerda was referring to in that separate piece,
Yeah,
right?
I think it's 564, but don't quote me on it. I may be
Right,
wrong
but
on the
you-
House
there
bill
were
number.
two pull-ups, so there's three part. Got it. Thank you so much.
All right, Bill Trombley. Good morning and welcome.
Good morning, Mr. Chairman. Good morning, committee members. My name is Bill Trombley. I'm a master plumber, a gas fitter, and a certified oil installer. I'm here representing the Plumbers, Fuel Gas Fitters, and HVAC Association. Our association is made up of mainly licensees. And with that, with this bill, we're not opposed to it. We're just looking for some tweaks in it, starting on page 16. And I think it was already mentioned earlier today, 16, starting at line 9, is most of our members are small business members. They're probably majority of the businesses in New Hampshire are 1 to 5 man shops. And we're talking about if there's an investigation that they can be charged for that investigation, we would also like to see a cap on that number, if that's all possible. And then moving on to page 17, again, it was already spoken to by Mr. Rancourt on the appeals of the decision of the hearing, is, again, with the plumbers and the fuel gas fitters, sometimes our hearings is about a code interpretation or something like that. And an appeal to the Supreme Court is very expensive for a small business owner. So we'd like to have that appeal to anything to do with a code violation to go to the Building Code and Review Board. I'll rehash what Mr. Rancourt has said. And then going on to page 19, starting at line 5, where it has the examination fees for the applicants of the license. I'm not quite sure how that will work for the plumbers and the gas fitters. Our examinations are being done by a private company, and the fees are set by the private company, not by the board or the administration. So that's a concern, and we don't know how that would work with our licensing. Also, the late renewals, there's something with the late renewals that should be set by the board. And this goes into what Mr. Rancourt was talking about, is that somebody can play the system. If there is no late renewal fee, they can hold off for 3 or 4 months or 5 months and then renew their license. And we're going to have some lost revenue in that case. Our expiration date should remain at the end of the month of our birth date. That's how it's been since 1980. So I don't see the reasoning why that we have to change the expiration date. All the administrative fees and everything else like that, we have no problem with the OPLC setting those fees, but anything that has to do with the licensing, the examination, and late fees should be set by the board or in consultation with the board or with the approval of the board. It should be the same thing as it's written with the licensing fees. Those have direct to the licensees. And the only other thing is, I think it's not in here, actually thinking, reviewing this today, it's in House Bill 2, is that we think that the OPLC should also be reporting to the board or to our board, at least on a monthly basis or quarterly basis, of what fees that we've collected, what expenses that we have done. I know in House Bill 2, I think I just saw it now, it's actually removing that out of our current law. And we'd like to keep that remaining in there. So I'll answer any questions.
Turn my mic on. Senator Altshuler.
Thank you, Mr. Chair, and thank you for taking my question. Regarding your statement about page 19, section 6, Roman numeral 3, on lines 5 and 6, could you, again, I was listening to a very succinct presentation. Could you tell me more about the fees that are set by your professional organizations that come in conflict with lines 5 and 6?
So right now it says the Office of Professional Licensing and Certification shall establish the fees for examination of applicants for licensees and certificates of authorization. That right now we have, if you go and you take your journeyman's plumbing license, a private company is doing that. The fee is set by that private company. That fee does not come to the state. It doesn't come to the board. Same thing as if you go take your master's plumbing license, that's done by a private company. Same thing with a gas fitter's license, all the gas fitters license, that's done by a private company as of right now. And the board currently does not have any say over that pricing that we have right now. We do review the private companies that is putting in on the test, and the actual test that is given is the test that is developed by the board. It's just this line, I don't know how that would work with conflicting with a private company given the exams. So
if this stays as written, would that mean that your people would have to pay the fees to take their certifications for, say, their master's plumber's license, and then this might establish a separate fee
yeah, the way I
to
would
go
see
to the board underneath the OPLC umbrella?
Yeah, you would have to, the way this is written, the way I read it, is that you would have to pay a fee to the OPLC, and then you would have to pay another fee for the licensing. Or the OPLC puts in that fee, they contract out a private company, and currently I think the fee is $100. And they either charge $100 or they charge $125. They put something on top of that. So it just, right now, the fees are paid directly to the provider. It doesn't go to the administration or the OPLC.
Thank you for the clarification. Thanks.
Further questions? Seeing none, we thank you. Is Ms. Kirkland still here? I realized that I missed a note here that you needed to leave soon. So if you want to come up next, and my apologies.
Good morning. The timing is fine. Thank you very much for accommodating me. So my name is Kimberly Kirkland. I'm a lawyer in Manchester. I represent plaintiffs in medical malpractice cases, and I'm the president-elect for the New Hampshire Association for Justice. But maybe more relevant to your proceeding here today is my background from 2000 until 2014. I was a tenured member of the faculty at UNH Law, then Franklin Pierce Law Center, and I taught civil procedure, which is the course that talks about the procedural rules that govern civil cases moving through the court system. And what I think is most important about what HB 655 is trying to achieve is the amendment of the process of investigation, prosecution, and adjudication of complaints about professionals within any profession. And within the court system, it's well understood that the investigatory function, the prosecutorial function has to be separated from the adjudicative function. So you don't want your jurors investigating and prosecuting a claim. And what this bill does is for each and every board under the auspices of the OPLC, put the investigatory and prosecutorial functions in the hands of the OPLC, which has the experience and skill and is empowered to hire experts in appropriate subject areas to help them thoroughly and objectively review complaints from the public. And that's essential to the protection of the public and us being assured that all the licensed professionals in the state are being fairly and objectively evaluated when there are complaints about their conduct in any circumstances. And I think it's probably common sense that this makes sense. I think particularly if you're talking about a board of professionals who are or prosecute somebody within their own profession, you come into that with a kind of there, but for the grace of God go I kind of thinking, as opposed to thinking about the position of the consumer or the client or the patient, depending on what type of board it is. The New Hampshire Supreme Court actually recognized the importance of separating investigation and prosecution from adjudication with attorney discipline in 2003. So New Hampshire was actually the last state in the country where a committee of volunteer lawyers investigated, prosecuted, and adjudicated claims that attorneys had violated disciplinary rules. And the New Hampshire Supreme Court recognized that you really needed a boundary between investigation, prosecution, and adjudication. And so they set up in 2004 the Attorney Discipline Office and appointed Londia McCafferty, who's now the Chief Judge of the U.S. District Court of New Hampshire, the first attorney discipline officer who prosecuted claims against lawyers in the state. I think that House Bill 655 will create a system where we can have independent, objective investigations and prosecutions. It leaves in the hands of the boards themselves the fact-finding. So the boards will determine whether an electrician, a plumber, a doctor, a nurse, a psychologist has done what the complainant accused them of doing. There will be a hearings officer from the OPLC who understands the law, and to the extent legal questions come up in that proceeding, can rule on those legal questions, but it will be the board that acts as the fact finder. I think that's most of what I wanted to say. I did hear some discussion about appeals just in the last couple of comments, and I'm not familiar with the process of disciplinary proceedings for other professions other than medicine. But I would say that I think it would be important in the appeals process to make sure that there is somebody qualified to make rulings of law as opposed to findings of fact. In appeals, often there are legal issues involved, and so you want somebody who has the background and expertise necessary to decide questions of law that come up in those appeals. I'm happy to take any questions.
Thank you. I think I actually understood what you said. Any questions? Seeing none. I appreciate you coming in.
Thank you very much.
Next, we'll have Chris Malevy from the PE Board, and Paul Mullen is also from the PE Board who signed in not wishing to speak. But Chris, come on up. There you go. You got it. Welcome.
Thanks very much for having me today. Again, my name is Chris Malevy. I'm here in the capacity as the chairman of the Board of Professional Engineers and also as a practicing professional engineer. I'm here to strongly encourage you to vote against certain aspects of New Hampshire House Bill 655, specifically page 4, line 15 through 19, relative to examinations for licensure and investigation of complaints as it relates to the Board of Professional Engineers. I have been honored to serve on the Professional Engineers Board since 2014 and have been the chair for the past 5 years. My board members and I volunteer our time to review engineering applicants for those individuals that wish to take the PE exam and for those applicants that are current professionals seeking to be licensed in the state of New Hampshire. We also serve as subject matter experts that work closely with the investigators for complaints or misconducts within the profession and assist in determining whether to investigate and adjudicate these cases. Our board consists of 5 members appointed by the governor and council. 4 of those are professional engineers that have varied backgrounds in the profession, whether it be myself, which is heavy highway and civil engineering, mechanical, electrical, environmental, etc. So we try to have a wide variety of those professionals so that we can serve our job in licensing these applicants. Together, this board brings 132 years of engineering experience to the board. We take these responsibilities very seriously in order to safeguard the health, safety, and welfare of the public of the state of New Hampshire. House Bill 655 in its current form transfers the authority to issue licenses from the Board of Professional Engineers to the Executive Director of the OPLC. Our board, consisting of subject matter experts, uses our knowledge and expertise to objectively determine if the applicants have the required expertise to sit for the exam and/or to be licensed in the state of New Hampshire. This proposed transfer of authority will also affect investigations and enforcement of complaints and misconduct within the profession. The decisions to investigate and adjudicate in these cases should lie with the board members who have the most qualifications and experience in the subject matter. By allowing this transfer of authority to the OPLC, the health, safety, and welfare of the public could be jeopardized. In closing, as a practicing professional engineer licensed in several states, and in my capacity as the chair of the Board of Professional Engineers, I am supportive of removing unnecessary barriers for professional licensure and to be more accessible to applicants without cumbersome regulations. However, through the state statutes establishing the New Hampshire Board of Professional Engineers, there already exists a proven and effective framework for licensing engineers in our state, ensuring the rigor is met to protect the health, safety, and welfare of the citizens of New Hampshire. I know it was mentioned earlier, but during the course of the pandemic, and I've been on the board for coming up on 10 years now, we've never had a delay. There's never been an issue with getting applicants that are qualified to become licensed in New Hampshire. I know that I've heard other members certainly speak today, and they mentioned House Bill 2. I won't mention any of those, but there's certainly some concerns in there as it relates to portability and licensure. So at the time that that's appropriate, you'll probably see me again speaking against that. That's all I have. I kept it under 3 minutes.
Thank you. Any questions? I think you did good. No questions.
Thanks very much.
Thank you for coming in. Did I leave you? All right, Dr. Deborah Warner. Good morning.
Good morning. I'm Dr. Deborah Warner. I have signed up twice. One is on behalf of the Board of Psychologists, and the other is my own opinion. Which one would you like me to start with?
You can start with either one you'd like.
Okay.
Put that hat on.
I don't wear this at meetings, but I'm speaking symbolically with the hat on behalf of the Board of Psychologists. You were emailed by our chair our position on House Bill 655. The board has not met since the new version has come over the Senate, but the points within that letter are still accurate and relevant. The board has has some issues with the structure of this, that you can skip to, if you're looking at that letter, some of the first one in terms of medical records has been appropriated into House Bill 655. So that's a very good thing. And we appreciate that the office did that. There are missing things in this bill that the board is concerned with. One is that currently in statute, RSA 329B 22, Roman 9, provides a summary of findings of evidence from an investigation in the event that the board wishes to go forward with discipline. If the licensee does not have that, then they can be encouraged to take a settlement agreement and accept discipline and punishment, even though they have not seen the evidence accumulated against them. This was put into statute a good dozen years ago. It is certainly appreciated by the licensees, especially if they ever get to that point. If you don't know what the evidence is that's been gathered, and you don't know whether or not somebody lied and made up infamous stories, or if they were telling the truth from your point of view, but it's a matter of the point of view, the licensee will take a different course of action in that regard. And they need to know that, and it's a common thing that you would want to know the evidence before you accept a punishment. In the 329B22 Roman 8 has the immediate notification of an allegation wherein the licensee can make a voluntary response. So that's an important feature that's not involved in this rendition of the 310 that's in front of you in that bill. The next item is B22 Roman 10. Loses that there is a distinction between an allegation and a complaint. You heard from Dr. Oliver earlier. This was set in place about a dozen years ago and actually was designed about 15 or more years ago by the Board of Mental Health Practice, and it was also picked up by the Board of Psychology, because allegations can come in from anything. In our profession, it could be they don't like the Kleenex, they don't like the codes that are used, they don't like maybe the dress of the person giving the services. And if those are dismissed, that licensee still has that check mark on their bad acts that they must answer to for all of these credentialing purposes. And as Dr. Oliver indicated, if you are not on an insurance panel, you don't get to serve patients from that who have that insurance, and there's less services available. It also is very important. It is protected in statute currently that you don't have to disclose the presence of an allegation, and that the board in its process takes the allegation, examines what it says, and determines whether or not it is actually a potential violation of a statute, a code, or law, and then they would elevate it to a complaint. And that's a legal status that then gets investigated formally. Those are the points that were made by the board in their letter to you and to the legislature. And that is the end of that portion of my presentation.
All right, any questions? Senator Perkins Coker.
Thank you, Chair. And thank you for your very thorough testimony. So my concern is that, none of these sections of RSA 329.
I'm sorry, can you put right on the microphone? I have a hearing impairment.
No problem, and I am a soft-spoken person. None of the sections of 329B22 that are mentioned in the Board of Psychologists letter are repealed by this bill as amended. So is your concern to clarify that in the procedures followed in 310, you'd like it to more closely mirror 329, or would language that 329 governs in specific instances help alleviate the concerns of the board?
Yes, that's an excellent question, which I will answer a little bit more when I take my hat off.
Okay, that's
all right.
fine. Yeah, I have other questions when you take your hat off too. Okay, thank you, Chair.
All right, looks like we're ready for the second half.
Okay, I'll take off my hat. I'm Dr. Deborah Warner from Littleton. I have a practice called Bright Day Psychology, and I also have another practice called Renovation Psychology. I help people remain sane while they work on their houses as well. It's a lot of fun. And also I have experience in my time as having been on the Board of Mental Health Practice, and as you know, I've served on this present board as well. I'd like to direct your attention to my handout that I passed out. It has a colored paperclip on it, and the first page says my name on the top. And this has, I have a little handwritten thing that changes it from subcommittee to Senate, and a little handwriting thing at the bottom that says, please, my suggested revision. I did email you ahead, and you have in front of you also a lot of red print of actual suggested revisions. I think that it is very important to note that this legislation is going to make the foundational statute for OPLC, and it's going to be replacing these other portions in just about all of the board chapters and sections. OPLC has indicated that's their intent, and even if it hasn't happened yet, they've indicated that's what they want to do. And in fact, we've seen it twice recently in two bills, HB2 and the earlier version of this, that they were knocking out those pieces. But in any case, it is their intent to fully replace that. And I'm not against this standardization of these things across the different boards, but it is very important that they get it to cover all of the due process issues that are currently in statute, but they would be lost if these chapters and sections get removed and OPLC relies fully on this statute in front of you. So if you were to look in, the one with all the red has the details, and the one on top has sort of the major points. So if you're a detail person, you can look at the red and the other. But there are rights currently in place that a practitioner would be able to see the allegation when it comes in. In my practice, it's very important that the psychologist would know if they have a patient whom they see every week has issues of the magnitude that they would communicate them to the board. And in fact, sometimes it happens that it's a psychological issue, that they might be getting paranoid, or they might be having a delusion about their therapist or something. Those things would be very, very important clinically and for the safety of the public and that patient to know. That's just on the practical issue, but also in terms of due process, it's important to know. In statute already, the licensee can submit a voluntary response, and this would be considered by the board. Now, if you look at the one with all the red in your thing, the board, the OPLC version of all of these processes and steps is about 2 inches of text at the very start of that document. But if you look below it, in 310:9, I've put in quite a bit more in order to reflect these pieces that are in other statutes. I believe that they are proper and good to put in for all of the boards. I personally, the board has not gotten the right to say what other boards should do, but I personally am very interested and well informed about these statutes, and I would highly recommend this. The way that these are not contrary to the process that was outlined in the bill as presented in 310:9 in Romans 1, 2, and 3. But it's not contrary to that, but it's a lot more detail. It also does not contradict the recommendations that we heard from the professor attorney recently, moments ago, in terms of the process of keeping things separate. But what happens is in this process, if you would like to look at these in more detail, I will be happy to go over them in general, in detail. But the allegation comes in, it gets sent to the licensee, the response, voluntary response comes back. Those two items side by side are given to the board, and the office, when they give them to the board, they can say, this recommendation, is it in your jurisdiction or not? The board can then look at them side by side and either dismiss them or elevate them to the status of complaint, at which point they issue a formal order of investigation. That formal order structures the investigation. A large concern I have is that as written, there's no structure at all. And in fact, the office can investigate on its own initiative. And instead, the board, knowing the profession and knowing what they're seeing as the suspected offenses, they would list those offenses code by code and law and as well as statute, regulate the rules.
All right, Dr. Warner, I've got to kind of move you along. We're well over 10 minutes in here.
Sure.
And I've got quite a few more on the list. So if you could wrap up in the next minute or so, would be
I
great.
shall be glad to do that. I think that what's really important here is that we structure this. I have detailed recommendations that come from statute, and I'd be happy to answer your questions about that.
Well, thank you. Any questions? Senator Perkins Coker.
I guess I just have one. I appreciate your very detailed attention to this. Did you work with anyone when you were drafting these changes, or are these just your, are these just your recommended changes, or did you work with anyone else in terms of drafting this red line you provided us?
I'm the local nerd in this
Okay.
way. There's a lot of people who I talk to about this, and psychologists and such, and yes.
Okay, thank you very much. Thank you, Chair.
Further questions? Seeing none, listen, we thank you for your testimony and the information you provided.
Okay, thank you. Oh, I do have one other point. May I, just one thing?
Real quick.
Slightly different topic. As in Mr. Rancourt had said that the problem is that the licensee, if they're found guilty, can be charged with the cost of the investigation. If you look at the very last page of the handout that I gave you, it does say there's several reasons why that's not appropriate. And in fact, there's another statute, RSA 332G:11, where it's almost identical to that issue, which I think also should be repealed. But that one at least has a cap of 10,000. This one, I believe, should be deleted because, first of all, law enforcement does not pass these costs along to criminals. Second of all, the burden of proof for our work in OPLC is much lower than that even in a criminal court. And the third thing is that the costs of the investigations are already calculated and included in the fees. So it's quite redundant. It's getting the money twice. It's punitive. It's unfair and unjust. So thank you.
Thank you. Omer Ahern. Good morning and welcome.
Thank you, Mr. Chairman. Can everybody hear me okay?
We always can, Omer.
Thank you. My name is Omer Ahern Jr. I am from Wentworth, Grafton County, New Hampshire. I am an attorney. A lot of the different professions that are indicated in this statute and bill, I kind of deal with in my other in my line of work as an attorney, but I'm also a Grafton County commissioner. And the last couple of years have been really tough on us because of the nursing shortage. And so the changes to this bill or to this legislation is really important in that I want to make sure that we continue to try to improve making nursing staffs available. And if there are allegations made against them, it's important that we protect their legal rights and let them know, what the what the complaint is against them, give them a chance to be able to respond appropriately. And I know if somebody has said a lot of the stuff that I would say, I'm supposed to, refer to them. So in essence, I agree 110% with the statements.
Of the 145 resident-owned communities in New Hampshire, resident-owned manufactured housing communities that rely on the Manufactured Housing Board, part of the OPLC, that was addressed in the prior version of this. And it's our intent, I won't go through my testimony, there's been great testimony already, to follow HB 2, HB 655, and of course, SB 203, that this committee really did remarkable work on behalf of the residents of Manufactured Housing Park to make sure that the work that was done there by this committee maintains in law. I will say I'm also a Merrimack County Commissioner, and I'll echo the prior commissioners' concerns about the nursing shortage. In fact, we have a long waiting list and could open another wing if we had the staff, in fact, to open that wing of the nursing home. But thank you to the committee. Would love to be a resource at any time you need.
So I feel the temporary licenses needs to be the same standard. I know we have an issue with, shortages in workers, but we should not put the public at risk just to meet that need. We need to keep the same high standards on there. That really concerns me on there. Especially, and I do fear on this whole, I don't really understand all this, but the 125%, and there's no cap on the amount of investigating, and just the fact that it's making money off of investigating. Well, I'm sure right now, we've got great people running that OPLC office, but this is a permanent change. And what if we do get the wrong people in there that are more corrupt, and that it's this whole setup of, and the more we investigate, the more money we can charge and make off of this licensure. And it's not about making money, it's about protecting the public. And I just want to make sure that that stays throughout that common thread here. We want to protect people. That's why we have the licensure here, to make sure people stay safe. Thank you. I also do have a letter from another dietitian.
Any questions for Ms. Moreau? Seeing none? I thank you for your testimony. I think we're good.
Thank you.
I also have Elise Bolster and Erica Berman that signed in opposition. I have Richard Silverman from the New Hampshire Board of Accountancy who's in opposition. Did you want to speak?
Yes, sir.
All right, come on up.
Good morning. My name is Richard Silverman. I'm a certified public accountant and the current chair of the New Hampshire Board of Accountancy. I've served on the board for 8 years, and the past 2 years as chairman. I'm attending today with the support of our entire board. I have already submitted to you a detailed testimony, but today wanted to summarize our overall general thoughts related to 655. As I said in my detailed testimony letter sent to each of you, the board understands the legislature's efforts to streamline procedures and supports those efforts. Our board's concern is that too much of the board's role is being slowly transferred away from the board to OPLC, which we certainly believe is with good intent, but which in our opinion will rob the profession of the underlying reason for the existence of our board. That being the board's expertise and experience in the accounting profession and collective knowledge of what works best for the optimization and protection of the public. Our starting point is statutory mandate provided to the board in New Hampshire Accountancy Act, and particularly RSA 309-B:4, which provides to the board the responsibility for the administration and enforcement of the act, and RSA 309-B:7, which provides the board with the authority to grant or renew licenses for applicants. Yet the recent legislation and rulemaking appears to be whittling away at the board's role. At least that is our current impression. The legacy of the board is protection of the public, and this responsibility is based on the expertise of the board members. In the past, the board has done an outstanding job in the areas of certification, licensure, enforcement, and discipline, and we feel OPLC cannot adequately represent the public without the expertise that the board has. The board needs to have the ability to override any decision by the executive director that the board, due to their expertise, deems not in the best interest of protecting the public. We recognize that some of the changes recently active are probably for the purpose of efficiency and perhaps expediency, but neither efficiency nor expediency can trump the overall mandate that established the authority of the board. Not in my letter, but discussed today was investigation, so I wanted to say just a couple words about that. We as a board have always appointed our own investigators when it regards technical matters. In one case, we have five CPAs and 2 public members. We look to our members to be an investigator, and if they sign on as the investigator, they are recused from any decision-making. In one particular case, I was the investigator. I put in over 50 hours. I was recused, and there was no charge to the state. In another example, another member was recused, put in numerous hours, no charge to the state. In another example, none of the 5 CPAs on the board had an expertise in a particular technical matter. We went outside to a partner of one of the members who did it at no cost to the state. So we feel this is important, that in any of the technical issue, the board plays a role in choosing the investigator. Excuse me. Lost my place. It is interesting to note that on Monday, the House removed from HB2 the provisions related to OPLC New Hampshire board changes. We feel this supports our position and casts a doubt on the appropriateness of the OPLC rule changes. In closing, I repeat again that the board has the knowledge and expertise in the profession to make appropriate determination on the issuance of licenses, certifications, and enforcement in our role in administering the New Hampshire Accountancy Act. It is our intent as a longstanding board to continue in that role. My testimony letter details the areas of our concerns. I'm here today to answer questions and any opportunity the committee might have, and I thank you for this opportunity.
Thank you for your testimony. Any questions? Senator Perkins Quokka.
Thank you, Chair. And thank you, Rich, for being here. Nice to see you. It seems to me from your letter that the Uniform Accountancy Act has some procedures for investigation, and those seem to govern what the Board of Accountancy does now. Do I have that correct?
That's correct.
And so it would seem the profession is somewhat unique in terms of having such a developed alternative statutory regime, essentially. And have we in New Hampshire adopted the Uniform Accountancy Act, or is it like a model policy that you follow?
It is the model, and we have adopted it, yes. And there are certain areas in that Uniform Accountancy Act that deal with licensure as well.
Yeah.
And especially and maintaining a license and continuing professional education. And this is important because of mobility, so that if a CPA from another state comes in and wants to practice in New Hampshire, we're assured that if they follow the Uniform Act in that state, have all the prerequisite requirements to become a CPA and have maintained their license with the continuing professional education, that it's acceptable to our state. And again, this is okay.
If we could, sir, and then Chair, I just have one more follow-up, if I may. It would seem to me that your last comment on the term limits for the executive director of the OPLC have been adopted in this version as amended. Would you agree?
I'm sorry, I didn't understand the question.
In the version of the bill as amended, it would seem the term limits for the executive director of OPLC have been adopted
Okay,
Would you agree?
yes.
Okay, thank you, Rich. Thank you, Chair.
Further questions?
I guess my question for you, Senator, is when I find out where in our current rules, the UAA is accepted, who do I send that to? I send it to you or the
Send it-
chair?
Send it to the whole board if you'd like.
To the whole board?
Yeah.
Yes.
Okay, like you
Thank
did the
you.
letter?
Yes.
Any other
Thank you.
questions?
I think that's it. Thank you.
Thank you.
So I have one more person on, Joseph. Not sure. Did you want to speak? All right, come on up. Good morning and welcome.
Good morning, Mr. Chairman. So my name is Joe Wickert. I'm a self-employed licensed land surveyor from Manchester, and I am the current vice chair of the Board of Land Surveyors for the state. So our board fully supports removing any obstacles to licensure, and I think we've been actively working for that during my tenure, which has been since 2015. Excuse me. We have been working to that end with both the national associations, state associations. We're in one of those professions that the other people have spoken about where we have a shortage of people. So we're, actively engaging to try to get younger people into the profession to move forward. Both the Board of Surveyors and Engineers were strongly opposed to the original wording of the bill. I think the revisions are moving in the right direction, so that's good to see for us. Our concern as the Board of Licensure for Surveyors is we believe that the current structure works well, and our concern is the wording of the bill, right? So the director testified relative to what the process would be, and I think that was encouraging to hear. But we read the bill that it seems to remove the boards from the process and kind of defers or directs all the authority to OPLC. And, with wording Trump's intent, and even though, if the wording could be tweaked, then maybe there'd be a little less opposition on our end. Mr. Malivi, who's the chair of the Board of Engineers, testified earlier about their concern was on page 4, lines 15 through 19 for the specific quote. And I believe those are valid in our concerns for the surveyors as well. In our specific case, we do not have an education requirement. And the reason there was no education requirement adopted is that has been perceived to be an obstacle to licensure. So because we don't have a specific education requirement, the ability to evaluate experience is more important. And I think that is best handled by somebody who has the experience and been in the profession and can understand it. For surveyors, we have a state-specific exam. That exam is administered twice annually. It's run by OPLC. We are trying to move to computer-based testing. I think that would be helpful to remove obstacles for if the new system were to be adopted. You don't have to fly to New Hampshire to take the exam. You could be taken at a different state. So we are, like I said earlier, we're trying to get there. Some of the previous speakers spoke about allegations could sometimes be found to be not worthy of an investigation. Under our current system, the board will make that initial determination, and should we deem it not to be worthy, we're not going forward, and we're not either putting a mark on somebody's record or expending the actual investigation if it's a civil matter and not a technical issue. We believe that, that is a better system. Some of the other speakers had also spoke about the cost of the investigations. In our world, sometimes there might be an issue, but maybe that issue is an interpretation or a poor decision versus malice. And I believe that, the punitive part of that might cause more issues than what would be the normal process. So I know it's late. I'll try to be brief. I'd be happy to answer any questions should anybody have one.
Any questions? I think you're going to get off easy.
Thank you very much.
Thank you for coming in. Is there anybody else that wants to speak on this? And that's the last one I have on the sheet. Director Courtney?
while our speaker's coming up. I do have a few questions that would be helpful to have OPLC come back on, but I'll leave that to Chair's discretion.
Sure. Introduce yourself.
Mr. Chairman, I'm Brad Holt. I'm an attorney at Sullivan and Hollis, and I'm really coming as an attorney who represents defendants before the board and has for many years, rather than speaking for the firm or for any organization. My concerns are that the initiation of the OPLC was designed to enhance efficiencies, reduce redundancies, that sort of thing, but it seems to be moving into a consolidation of discretion to the staff of the OPLC and removing it from the Board of Medicine, which has historically had that function, has the statutory authority to do.
They have appreciated the authority to do so. And then finally, I want to address the allegation versus complaint. And what I can do is send the committee our existing procedural rules for investigations that already contemplate this process. So currently, when we receive a complaint, we send a letter out to the licensee unless there's a criminal component and it could potentially be harmful to do so. That person is given an opportunity to respond if they'd like. And then it goes to the board. The board reviews the response, they review the complaint, and they determine whether or not to initiate a formal investigation. At that point, in order, a formal investigation should follow. So I think from my perspective, it doesn't matter what we call it. We get a complaint, and then at some point it's determined to be formally investigated. The language doesn't really matter from our purposes. There is that initial review done by all boards, whether it's called an allegation versus a complaint. Whether or not one is required to report that to an insurance carrier, from my perspective, depends on what that contract with the carrier requires. And I don't think we can legislate around those contractual requirements.
So can I ask a question?
Yes.
So current procedure is a complaint comes in, the board decides whether to initiate an investigation. Will that power still remain with the boards if we enact House 655, whether to initiate the investigation, or will that authority move over to OPLC?
So what would happen under the statute is we would receive a complaint and we would conduct an analysis to see whether or not it states a claim on its face. And if we don't think it states a claim on its face, we would forward that to the board. The board could choose to dismiss. If the board says, no, we think it states a claim on its face, then we would proceed with an investigation. If when we receive it, we think it states a claim on its face, we would just investigate. So that would eliminate that middle process, if you will. I think many professionals, not just mental health professionals, work in an area where they may be more subject to more complaints than others. I used to represent New Hampshire Hospital, and I can tell you I've had complaints that aren't docketed just by virtue of the work that I did. So it's not unique to one or two professions, and we can certainly draft rules that would support the existing framework around that.
Thank you.
That's all I wanted to clarify. I'd be happy to answer any additional questions, but thank you for the additional time.
Any further questions? Did you have a few?
I do.
All right, Senator Perkins-Corbett.
Thank you for coming back. I'll just keep on that theme. So are the rules that you guys have in place, are those pursuant to 332G for investigations?
They're actually pursuant to 310A.
To 310A.
And I can send you those draft rules. Basically, that statute authorized us to draft procedural rules regarding investigations. It's been difficult because there are over 50 practice acts. So to have one set of procedural rules, we really should have one enabling statute, which is what this is intended to address. We have 3 prosecutors, and we now have 8 investigators. To ask those folks to utilize 50 different sets of procedural rules has created significant issues with making sure that we're actually following the rules. As a litigator, I knew off the top of my head 2 sets of rules. And when I had to go into a different court, it was uncomfortable because I had to constantly checking the procedural rules to make sure that I wasn't making any missteps. To have over 50 sets of procedural rules is certainly problematic.
Okay. I think it would be very helpful for us to see it just because, would you believe, I think everything you're saying sounds very reasonable. I think the intent would be just to make sure that your procedural rules, this enabling statute, if I may, Chair. Okay. Thank you for addressing, sort of the license renewal piece. I think for me, there's still sort of a gap dealing with apprenticeship, and I know that's especially important in the field of electricians, which is important to many things these days. So maybe you could just direct us to how that's handled.
Yeah, so under 541A, a license, registration, certification is all the same thing under the law. So it's basically permission to practice. And so we believe that the current provisions of 310A, setting forth the licensure timeframes, apply to basically everything under the office, whether it's called a registration, a license, or certification. It's permission from the state to practice in your particular profession. So I think there would have to be, if for a public policy reason, there is a need to carve out apprentices from having the 2-year renewal timeframe. I think there would be a need to specifically exempt those individuals.
Okay, that's helpful. And then just 2 more questions, I think, related to this investigation point. One is, you made reference to the fact that you're dealing with 50 boards and 50 sets of rules. So I think, for example, the Board of Accountancy, kind of bringing up this Uniform Accountancy Act, if we enact this enabling statute, assuming that the rules in place would operate under the language we settle on, for example, would the Board of Accountancy continue to operate under the Uniform Accountancy Act, or would your rules presume to take precedence over the investigation?
Yeah, I think from a statutory construction standpoint, whatever statute that was enacted later would likely control it, assuming that it's specific enough. So I think OPLC's statute would control. Now, what constitutes misconduct can certainly be governed by the Practice Act. So our statute would be intended to set forth the process for investigations, but what constitutes misconduct is going to be very different across the professions. And I think that that's what the Practice Acts are really intended to address.
Okay.
From a due process standpoint, there should be no need to have any differences in procedures.
Okay, so follow up if I may, Chair. So the Practice Acts are really to deal with sort of the substance, the industry standards, whether someone has acted consistent with practices in their field. Your rules presume to kind of create some uniformity in terms of the procedures that are followed, making sure complaints are acted upon in a timely manner, and that, boards kind of have consistency between them. Okay, that's helpful. I think having the procedural rules will be very helpful. And then I understand your point about the cost of investigations, but I guess addressing sort of where this $10,000 cap procedurally lived before and why we're getting so much feedback that it's being removed, would be helpful to understand from your perspective.
I think some statutes have a cap, some statutes don't have a cap. So I don't know precisely why a cap wasn't included in this one. I will note that our investigative costs for the large majority of boards, they lapse into the general fund. So this idea that we can use investigative costs to just generate funds is not accurate. We don't keep the money that we receive from investigative costs.
Okay, thank you. And then just 2 more, if I may, Chair. I understand that, on page 4, line 17, we have this idea that we're going to that we're going to operate under the idea that where applications for licensure contain objective standards, those would become an administrative approval. But it's my understanding from my limited experience with you guys that many applications for licensure include also a subjective criteria. So it may be that your board can, or your staff can act to sort of evaluate, multiple choice questions or checking the box in terms of whether a transcript contains the right criteria. But when it comes to, sort of answering essay type questions, those pieces of the licensure application would still be referred to the board. And so just to clarify for the record, that's sort of the practice you guys are trying to codify here.
Yes, I will say that the committee that was established by Senate Bill 330 last year did talk about subjective standards, and the governor actually issued an executive order back in December 2019 to direct boards to eliminate subjective requirements. There is an issue with subjective requirements because it can necessarily injects bias into the process.
Sure.
So there are policy reasons why we should probably attempt to eliminate subjective requirements, but if there are subjective requirements, we would not be able to adjudicate those in the office, and those would have to be referred to the board.
Okay, thank you. And then just one last question, which I know deals with HB2, but since we're here, I just wanted to get your perspective on it. I'm getting a lot of feedback about this change to the board on engineers and land surveyors kind of being combined, and I just wanted to hear your brief comments on it.
Yeah, there are several, actually only 9 states have a standalone engineering board. Many states have a combine engineers with another discipline. And so it's not uncommon. They are both utilize NCEES for examination services and support. So in terms of the governor's overall structure of trying to reduce bureaucracy or the number of boards, just generally speaking, there's a precedent for combining those 2 boards.
Okay, thank you so much, Chair.
Any questions? I do have one more myself.
Sure.
So I'm going to go back to the investigations. So if a complaint comes in and you determine that there isn't, any justification to it, and the board agrees with you, what happens with that complaint? Does it remain on the file of the person who the complaint was filed against, or is it removed, or what's the process for that?
I have to look into my retention schedule. I know historically the Board of Medicine, I believe, had a permanent retention on complaints. They're certainly not contained in the licensing record. I would have to get back to you on the retention schedule.
Yeah, because I can understand why that could be problematic for someone who's, going forward if they were looking for any number of reasons why it could be.
Yeah, I mean, so it goes, I can see both arguments to this, because if you have a pattern of receiving these types of complaints and they are all independently not enough to warrant potential investigation, but you've received 50 of them, then that may be enough to say maybe there's something more here and we want to investigate. So I can see both sides to it, but personally there should be and I believe this is what our retention schedule addresses, which I can get for the committee, there should be a certain time period in which those prior complaints are considered stale, such that they don't have any probative value.
Okay, thank you. Further questions from the committee? All right, thank you.
Thank you for your time.
Dr. Warner, I see you have your hand up. Did you have a further comment? I'm going to give you like 1 minute because we're about done here, so come on back.
It's very much appreciated. Thank you. I'd like to just point out the qualifications for a license aren't just objective or subjective. They're also qualitative. And qualitative cannot be easily scored by an office staff. Qualitative might be an evaluation of an exam question, an essay question, something like that, that pertains to professional standards and codes. The other point I want to bring up is that Executive Director Courtney did say that it doesn't matter to her what the terminology is for an incoming allegation, that it could be an allegation or a complaint. And if it doesn't make any difference to her, and it's greatly important to the licensees, I would suggest we go with that bifurcation between the allegation status and then it gets elevated to a complaint status by the board legally. Thank you.
All right, I'm going to close the hearing if there's no one else that would like to speak. And since I see none, I'm going to close the hearing on House Bill 655, and I thank you all. This has been a lot of information for us to take in, but we appreciate everyone that came in. All right, with the closing of that hearing, I believe our work is done for today. I thank you to the committee for sitting through, and we will convene next week.